So New York just told the Supreme Court to uphold their concealed carry restrictions and to ignore the text, history, and tradition of the Second Amendment. So let's talk about this. But real quick, before we jump into this video, if you think that the Second Amendment protects your right to carry a firearm out in public for your self-defense, go ahead and hit that like button and subscribe. Also, I want to thank one of the new sponsors of the channel, which is Acre Gold. Acre Gold has a subscription program that lets you subscribe to gold bars for as little as $30 a month. You pay each month, and once you reach the price of their gold bars, they discreetly ship the gold bars to your house. Acre Gold lets you invest in physical gold without the full price of the gold coming out of your pocket all at once. So if you would like to start investing in gold today, you can visit the link provided down in the details section. Also, I want to let you know that this content is powered by the Firearms Policy Coalition. So head on over to joinfpc.org to help support the Second Amendment cause. Thank you again, Firearms Policy Coalition, for supporting this channel. So what we're going to be talking about in this video is an update in the New York State Rifle and Pistol Association v. Bruen/Corlett case, which is the New York Concealed Carry Permit Challenge, which is now up to the Supreme Court. And the Supreme Court will be hearing oral arguments on this case on November 3rd. Well, we have an update on this case, and that is that the state of New York has filed their opposition brief, and they have made some arguments in their brief to the Supreme Court about why this is not a legitimate challenge and why instead the Supreme Court should uphold their concealed carry permit scheme in the state of New York. So let's take a look at what the state of New York is arguing and why they say that the Supreme Court should uphold what they're doing with their carry permit scheme. Now, first, right off the bat, there are questions presented in both the opening brief of the New York State Rifle and Pistol Association in their opening brief, and then also in the opening brief of the state of New York. And here, just right off the bat, you will see a very drastic difference. And that question, and the real question that they will be addressing, is whether the state's denial of petitioners' applications for concealed carry licenses for self-defense violates the Second Amendment. So that's the question presented that the Supreme Court said they will address, and that is the same question presented that New York State Rifle and Pistol Association included in their brief. Well, in contrast, the state of New York stated that the question presented is actually whether the restrictions placed on petitioners' concealed carry licenses violate the Second Amendment. Now, it's going to be interesting to see how the Supreme Court addresses this, and maybe they will address this in the oral arguments. But just right there off the bat, you can see that the questions presented that the state of New York is addressing in their brief is actually different than the question presented the Supreme Court said itself they will address. The next thing, which is also important for just background on this case, were the included facts, and these are also a little bit skewed because they are facts based on what the state of New York is including in their brief. So there are two individuals here, Robert Nash and Brandon Koch, who live in a county in New York. And they live in this area, and it's a little bit more rural, and there are some kind of mid-sized cities as well. These individuals allege that they applied for unrestricted licenses to carry concealed firearms in public for self-defense and other purposes. And they were granted licenses, but they were granted licenses restricted to hunting and target only. And because these individuals could not carry a firearm for their self-defense out in public, they decided to challenge this permit scheme. And that's how it's ended its way up into the Supreme Court, where now the Supreme Court will be addressing this New York carry permit scheme and whether or not self-defense is a good enough justification for someone to be able to carry a concealed firearm out in public. Now, in this brief about why the Supreme Court should actually find that what the state of New York is doing is constitutional, there are two main arguments. The first main argument is that text, history, and tradition indicated the state's ability to restrict concealed carry in public places. So there, the state of New York is saying text, history, and tradition is on their side, and text, history, and tradition point to the fact that they can have these types of restrictions. The second main argument that they're making is that means-end scrutiny is appropriate when looking at this issue, and that their law actually would pass means-end scrutiny, specifically intermediate scrutiny. So on this text, history, and tradition section, the first argument that the state of New York makes is that the text of the Second Amendment does not enshrine an unqualified right to carry concealed firearms virtually any public place. Here in this section, New York points to the statements made by Scalia in the Heller v. DC Supreme Court decision. If you're not familiar with what that is one of the most significant and the biggest and the landmark decision we have on the Second Amendment. And they are using some statements made by Scalia in that decision to uphold and say that the Supreme Court should uphold their restrictions here on carry permits. The state of New York states that the scope of the Second Amendment right to bear arms thus cannot be deduced from the proposition Not disputed here that it entails an individual right to carry arms for self-defense beyond the home. History and tradition play a crucial role in defining the scope of that right, and they conclusively confirm the validity of New York's handgun licensing law. So here they're saying by the text alone you can't determine the scope of the Second Amendment, and therefore you have to turn to history and tradition. Now let's take a look at that quote from Scalia. Scalia stated, "Like most rights, the Second Amendment's right is not unlimited. It is not a right to keep and carry any weapon whatsoever in any manner whatsoever and for whatever purpose. For example, concealed weapons prohibitions have been upheld under the amendment or state analogs. The court's opinion should not be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places, such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of arms." Now, this is an unfortunate piece of Heller's opinion that is latched on to a lot by anti-gun advocates when they argue these types of cases, and they usually use this as a justification and some kind of case law to point to say that these types of firearm restrictions are valid. However, despite all that, the important piece of that sentence is long-standing prohibitions. This points to historical and traditional restrictions of firearms. Barring people from carrying firearms in public for self-defense is not a long-standing or historical prohibition. That very sentence doesn't even state that. Essentially, there were some restrictions on a person's ability to carry firearms in public, but only if a person carried a dangerous and unusual weapon in such a manner as will naturally cause a terror to the people. That is the language that you saw in a lot of these laws. It said that you could carry firearms, but you couldn't carry dangerous and unusual weapons in such a manner that would naturally cause terror to the public or to the people. But a lot of times, even then, there were these bond mechanisms that you would pay for just in case anything, I guess, would happen. So it wasn't like there really was a restriction in some of these areas. Now, again, I'm not any historian. I haven't dug super deep into this, but you see a lot of these arguments pop up. You've seen some discussion about history, tradition, text, all of that in cases like Young v. Hawaii. But with all of that, the issue is that the state of New York is not being historically consistent to what they're even pointing to. Someone carrying a Glock 19 concealed in a Kydex holster on their waist when they're going to a grocery store that no one would even notice is not something that is dangerous and unusual or is being carried in a way that would cause terror to the people. So a big portion of this brief is spent on text, history, and tradition, and the state of New York's whole argument there is that text, history, and tradition supports the types of restrictions that they are doing, and I think that's really comical to a lot of us for the state of New York to say that our founding fathers, with their text that they wrote, the history and tradition surrounding the ratification of the Second Amendment would lead to these types of restrictions or would support these types of restrictions. That's pretty comical to me and to a lot of us who would read this brief, but that's what the state of New York is arguing. Now, the second main argument that they make in this brief is that means end scrutiny is appropriate here and that their law would pass intermediate scrutiny. This is something we talk about a lot in these cases. I'm not going to go super deep into this. Essentially, they're saying that the type of analysis that should be applied in this case is a lower bar type of analysis, which would be intermediate scrutiny. And usually the government wants this type of analysis because it's really easy for them to pass it. So this brief is interesting because it gives you some insight about how the state of New York is going to argue before the Supreme Court, what type of arguments they're going to make. Now we will see how the Supreme Court addresses some of these issues when they have oral arguments on November 3rd. I will definitely be listening to those. I think I had mentioned in the past that I would like to do sort of a live stream reaction to those oral arguments. If you guys are interested in that, definitely drop a comment down below that you would be interested in kind of doing a live stream reaction to that. And I think it would be really interesting to kind of just listen to this, what's likely going to be a landmark Second Amendment case with a lot of you guys. So if you have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Algor's rhythm. It signals to YouTube that you guys see value in these videos, in this type of two-way news, and then it pushes it to more people. So thank you so much to everybody who's liked, commented, subscribed, who's hit the notification bell. You guys are definitely impacting these videos, impacting this channel. We are gaining a ton of new followers because of you guys, because of your interactions with this channel. So thank you so much. We're marching toward 200,000 subscribers. And if you're a new subscriber, go ahead and comment down below that you're a new subscriber and I will definitely comment back to you. So as always, thank you all for watching. Don't forget to like and subscribe, and never forget this station was built by armed scholars and the station will be maintained by armed scholars.